So today we're going to dive into some of the specifics about how you register a trademark. In other videos, we've talked about the trademark system generally, and I've given you a basic overview about the registration process. Here, what I want to do is go into a little bit more detail about how registration actually operates. So the first stage in a trademark registration is the application. You can fill this out online these days, or you can do it by paper, but either way there's a prescribed form. There's a form that IP Australia actually provides for this. And this is regulated by Section 27 of the Act. And it says that this is the nature of the form that has to be put in. And most importantly, that what you have to do is you have to specify what is the sign which is being applied for and what is the class in which it is being applied for in relation to what sorts of goods or services. In other videos, we've talked about the class system and the way in which that works. So here, I'm not going to talk about that, but basically the two things that you have to do in applying for a trademark is you have to specify the thing that's operating as a sign first, and then you have to say in which particular class is it going to operate. The thing that's operating as a sign is usually going to be a word or a symbol. And we've talked about this in other classes, in other videos. The thing here is, of course, it must be distinctive. So usually you want to have something like an invented word or a word that's used in other contexts, or you might want a graphic that has been created, something like a logo. Those are the sort of the two basic sort of ideas, the easiest ones to work with, a word or a symbol. Other sorts of marks like color or shapes are a little bit more complicated. You can do that, but you're going to need some expert advice and it becomes a little bit difficult as you go along. So once you've specified that, then what you do is you specify in which class this particular mark is going to be registered or that you seek to register. And what you do, if you go online now, you can take a look at the international class system of the trademark system, and there are 45 classes. We've talked about this in other videos, right? And what you do is you work out what is the closest one to this particular thing that you are seeking to register. So, just as an example, Class 5 deals with drugs. So if you are seeking to register a drug, a new sort of drug or a new name for a drug, then you'll seek a registration in relation to Class 5. There are lots of other classes, obviously. There are 34 goods classes and 11 service classes, right? And so what you do is you look down through that list and you make the best guess that you can. And obviously, with practice, you get better at working out which one it's going to be in. The examiner of the trademark may take a look at what you're seeking to register and may suggest or get back to you that in fact you need to change the class, right? Or in fact may suggest that in fact that this is actually not eligible for registration because somebody else has registered it. And this is a really important part of the second stage in the process, which is the examination process. The main reasons why you won't get registered in this second stage, once you've applied for the mark, right? The main reasons are really twofold. First, that someone already has a registration in that class that's deceptively similar, right? Or confusing to your particular, confusingly similar to your the mark that you are seeking to register. So there's no point in seeking to register the word Nike, right, in relation to things which are close to shoes, right? So clothes, right? It's not going to work. And even a whole range of other things like sporting goods, right? Other classes that are fairly similar to shoes, you won't be able to register because the examiner will take a look and say, no, that's confusingly or deceptively similar to marks that are already registered. So that's the first main reason why you won't get it. The second main reason why you won't get it is if it's scandalous, right? That is to say, if you seek to register a swear word or some other objectionable content as a word or, for example, as a graphic, right, then the examiner will knock you back on the basis that that's impermissible. There are a number of other ways in which you can fail registration. You can fail the examination process, but you can take a look at those and we'll go through those another time. The third stage of the process is where the examiner makes a decision about your particular application. So there's what is called a presumption of registrability. That is to say, the mark will be registered unless it happens to be knocked out by any of the requirements that we've just talked about. There are some other ones. These are in Part 4, Division 2 of the Act. The other basis that the examiner can knock it back is that you simply failed to apply in the form that you should have applied. But lots and lots of marks get through this process, and if they don't, then typically what will happen is that the examiner, not typically, in fact what will always happen, is the examiner will notify you of that particular decision, right? And then you have the opportunity of remedying that decision and reapplying. Assuming that you get through that particular process, what happens then in the fourth stage is that the mark is published for opposition. This is published in what's called the Official Journal, and all trademark attorneys and all lawyers that work in intellectual property will get an automatic update of this particular information. Once it's published for opposition, there's a 3-month window in which other people can oppose that registration. So they can say that they are affected by this particular decision. Now, in that particular process, what happens is that lots and lots of lawyers around Australia, right, and internationally, will keep an eye out to see whether your application somehow affects the interests of their client. Now, their interests of their client could be extremely unusual. They might, for example, say that there is some distant relationship between your brand, the one that you are seeking to get a trademark over, and the particular mark that they have. Usually what happens at that particular point is that they will lodge an opposition and they will seek costs against the person applying for this particular mark, and they will try to shut it down. And this happens a great deal with large owners of trademarks. The trademarks that we all know and love, the ones that are really very well known, that are very famous, right? And so there, what you have is a situation where it's a bad idea to apply for a trademark that's very, very close to a famous mark that's already out there. When I was back in practice, what used to happen a lot was that clients would come in and say, I want to register a mark that was quite similar to a well-known mark, because they thought they would get some competitive advantage over their competitors by being able to use a mark that was similar to, say, Nike or Holden or Ford or whatever it might be. That's a really bad idea for 2 reasons. First is that generally speaking, you won't be able to get it through the registration system. The examiner in the second stage will knock it back when he or she looks at your particular application. Even assuming that you can get it through, during the fourth stage, during the opposition stage, right, you can guarantee that the lawyers for Holden or Ford or whoever it is will oppose that registration. And they will be prepared to fight a battle in court to demonstrate that in fact that you actually have no rights in this particular name and that their rights would be infringed by this particular registration. The basis upon which most oppositions take place is that the registration of this mark would be confusingly similar or deceptive to the public. And that's the basis upon which an examiner will normally knock it back. But an opposer, somebody who already has rights in a trademark, can oppose during the fourth stage. Finally, we have stage 5. If you've got through an opposition, or if there's been no opposition during the prescribed period of 3 months, then Section 68 of the Act says that the registrar must register the trademark once it's been through this particular process. That then means that you have 10 years of protection, and that 10 years of protection starts from the date of filing. So sometimes if it's been a long process, you actually have the point where something that you registered or that you sought to register 6 months ago, right, gets registered as of that particular date. And so you can actually bring an infringement action from way back when you filed the action, even though people may not have been aware of your registration at that time because it hadn't been published or published for opposition. So, the things to understand in relation to this, right? There are 5 stages. We've talked about this in this video and in other videos, right? The thing to note about the trademark system is that if you are working in this particular area, right, you should always check the trademark register. You should check to see what trademarks are actually in existence on the register and how you actually may go about getting around those particular ones. because of the fact that you can't register confusingly similar marks to ones which are already there, right, then you have to find ways around that. If your client comes in and seeks to have a mark that's somewhat similar to existing marks, and trust me, that happens all of the time. There are tons and tons and tons, literally thousands, if not tens of thousands of marks which are registered every single year, and you have to be aware of the fact that that may influence the interests of your particular client. So go and have a look at the Trademark Register. It's online at IP Australia, and you'll be able to see what people are registering, and you'll have a better understanding about the 5 stages in the process of registration.